Good afternoon. Hello, everybody. Thanks for being here. I'm here to introduce Kristian Pujol, who is going to be our presenter today. We're grateful to him and One Legal for putting this program together. Kristian has 25 years of experience in service of process and legal support services, so we have a real expert on this topic here today. He's the director of fulfillment at One Legal, which is an InfoTrack company. I'm sure you've heard of that group. Kristian oversees all process serving and court filing activities for One Legal. He's also the current president and legislative co-chair of the California Association of Legal Support Professionals. Lastly, he is a UCLA and UCSB graduate. So he's a local guy. Love it. I think he was at the Valley. He was in the Valley at some point, so maybe he'll chat about that. And finally, he is a U.S. Air Force veteran. Thank you, Kristian. And I'll pass it over to you with that. Thanks.
Thanks, Seth, and thank you, Linda, and thanks everyone for having me. It's good to be here. I am a San Fernando Valley native, so it's good to be here. Today, I'm going to be presenting on why service of process sometimes fails, and kind of see if we could identify different areas to try and mitigate the phenomenon. On the agenda, I'm going to go over some of the challenges we have with people. People could mean process servers, defendants, the types of people we're trying to serve. Also going to talk a little bit about the processes in place for process servers in California. Then we'll get into a little bit of workflow and communication, kind of like what you can do, what the paralegals and legal secretaries, and what One Legal can do to try and help avoid failure on service of process, and then also finally discuss some external factors that contribute to uh, the challenges we face out there as process servers. It's real easy to blame evasive defendants on when a service fails. But I think there's a lot more to it than just an evasive individual. I think it's really important to look at the issues holistically. Most social scientists usually look at problems in 3 or 4 different levels of analysis, and I thought I'd incorporate this into our topic today to kind of look at it at a more holistic level, where we will address, like I said earlier, individuals, also groups, or the state of California and the rules that we're bounded by, and also the system, not just the legal system, but the current political climate and economic conditions in the United States of America. And hopefully find an open door here. The key to process serving is to get the door, to get somebody to open the door. That is what I tell most people is the key, to have the person actually identify themselves. So I'm going to start with the people. And lawyers are difficult people to serve, for example. I wanted to talk about different types of defendants or litigants that we sometimes try to serve and fail to do so, oftentimes because of access restrictions. In my 25 years, I've worked for many law firms, and I still to this day laugh when I think about, sometimes I'll have a motion to serve on a law firm, say a customer of mine, and that I know really well, and I go to the law firm, and the documents are for attorney so and so. And when they let me know that the attorney's not available, I ask for their legal secretary. And then you see all the secretaries kind of running around the lobby. No one wants to accept service, and so forth. And I end up having to leave it with the receptionist. And so even attorneys who are involved in active participants in the legal process are sometimes apprehensive to accept service of process. And I find that kind of funny. Now, that's an example of secondary service, like serving a motion vis-a-vis 1011 CCP codes. But when we're serving an attorney on behalf of a defendant, it can sometimes cause issues with the proof. For example, if we're serving XYZ company, and the customer asks us to serve the attorney that's representing them on the proof of service, we're going to have XYZ company in care of um, Mr. William Carey, right? And so if we go there and no one's willing to accept, if Mr. Carey doesn't come out and accept service, we end up having to serve someone else. And so when you look at the POS 10 for summonses and complaints, you're going to have this personal service by serving XYZ and company in care of William Carey by leaving the documents with Linda Nelson. So it could cause issues, and you can understand how that proof of service might be questioned later on. So it's always best if we're going to serve an attorney to make sure that they're amicable and that they're maybe we can set up a time to meet them so we can personally serve attorneys. A lot of these professionals are obviously quite busy, like doctors also are typically difficult to locate. ER doctors, I've had customers ask me to serve doctors at hospitals because that's the only place they know they're at. Most doctors have their private practice, and oftentimes we end up having to go to the risk management or HR, and they don't want to accept because the doctors don't actually work for the hospital. They volunteer. For subpoenas, for example, if the subpoenas are for records of the hospital, say UCLA Medical or Los Robles, that's one thing. But if the subpoena is made out to the actual doctor, many of these facilities refuse to accept. And so services fail oftentimes if the documents don't have the proper person listed, or when they're in these difficult types of places to serve. Teachers, obviously, with all the gun violence in America the last 2 decades, schools are not very easy to access. We go sometimes to these schools and they're not going to let you in. Teachers are typically teaching, and so it takes a lot of coordination. Active military personnel is another one that often it's a 50-50. I've had attorneys call me and say, Kristian, I want to serve this person, but he's active military. What do we need to do, right? And so we need to coordinate with the JAG. And even when the JAG is able to locate them on base, they are by no means obligated to accept service. Sometimes we make an appointment and the defendant does not appear at the JAG's office. And of course we're going to have an unhappy customer because we have to pay the process server, and we have to charge the attorney's office for the time. And so active military are sometimes difficult to serve. And believe it or not, prisoners, you think it's really easy and they're not going anywhere. They're there. But oftentimes there's a lot of restrictions on access to incarcerated people. Prisons are typically often remote. When they're in a county jail, it's a lot different than in an actual prison. But CalSPRO, our state association, passed the bill about 2 years ago, SB 1040, which actually granted us more access to prisons and require prisons to have a legal coordinator to accept service of process. Believe it or not, though, certain types of documents that require personal service are still not acceptable to the state. Evasive parties. Obviously, these are the ones that are, when we try to serve defendants or judgment debtors at their homes, they are obviously, when they're evasive, it could cause some challenges for us. One thing that I would say is I oftentimes get papers from customers who said, "Hey, Kristian, I tried serving him. We sent the sheriffs out and they couldn't get it." The sheriffs are very busy. The sheriffs are going to go 3 times. I believe their sheriff's fees went up last year to $50, and it's very cost effective. But they're very busy catching criminals and protecting law and order. And so for them to do non-mandated civil, especially service of process, is a very low priority to them. And what usually ends up happening is they go 3 times and knock on the door. If the person is a criminal or maybe they're hiding, they're not going to answer the door to a police officer. And so now they've been alerted that they're trying to be served. And so I always tell customers, let me know, or if you try serving them by mail, and they don't return the acknowledgement of receipt, that also obviously lets them know that they're trying to be served. They actually now have the documents, and so are going to be evasive. So if you can tell your clients when you're going to serve like a family case, usually there's a lot of emotion, and you hear litigants say, "I'm going to serve you," that sort of thing. It doesn't do any good. I think it's better to, leave it to the process. Let us do it, and there's no need to inform them if at all possible. Celebrities, obviously in California, we serve celebrities. I've had attorneys ask me, Kristian, I want you to serve this football player as they're coming out of the field over at SoFi Stadium. How much was that going to cost me, right? And so there's better ways of doing that, right? We can make contact with the with their agent or with their sports attorney, and we can make an appointment and try to serve them in a different way. But I do get these odd requests sometimes, and we have served many celebrities in the past, but they're not always that simple, obviously, because they're shielded from the public, they have bodyguards, and so forth. I always say to people, anybody can serve a paper. I'll go over the rules shortly. Anybody over the age of 18 in California can serve up to 10 papers. But a real process server, somebody who really knows what they're doing, can serve in order for reexamination of assets and what we call an ORAP or an OEX. These are judgment debtors. And they typically know they owe money, they have judgments against them, and they're privy to the service. And so I always say, good process servers can actually serve ORAPs. And those types of documents obviously are challenging because many times they're trying to evade service. These types of documents used to require that you serve them 10 court days before the hearing. That law changed last year. It is now 30 days before the hearing on a debtor's exam. And so I still get ORAP sometimes that are, the hearings next week that they want service on. So even if you serve them, the service could be invalidated or quashed because of the statutory restrictions. So be careful with those. Descriptions on proof sometimes could be a cause for somebody trying to quash service because the description doesn't match what the actual person looks like, or they change, they dye their hair. So we try not to provide descriptions on proofs of services unless it's mandated. We will provide descriptions on substitute services and that sort of thing, but it's up to you. So let us know if that's something that you want or do not want. All right, process servers. Poor old process servers always get a bad rap. There's to be a process server, there are certain requirements. They do have to pass a background check. They have to get a bond. You register at the county level. You can serve anywhere in California. You have to be 18 years of age and not a party to the case. The beautiful thing about process serving is that they're supposed to serve as a third party, a non-biased party. And so when I see exemptions from registrations, an attorney and their employees can serve them, but I would question that there is a bias there, right? So I always tell people, don't have your cousin serve it or your spouse serve it. Hire a server to do it. They have no fiduciary interest in the case, whether it's served or not. They're there to help. And in California, the registration costs about $400 once you get the bond and everything. Certain types of people are exempt from registration. Like I said, attorneys, private investigators, professional photocopiers are meant only for subpoenas. But I will tell you, only registered process servers or sheriffs can actually legally serve writs of execution, ORAPs, which is what I was talking about earlier, and prejudgment claims. These are some of the documents that cannot be served by a private investigator, a professional photocopier, or even an attorney. Requirements for process servers differ by state. You can see here in Arizona, there's actually a test you have to pass. Unfortunately, in California, there is no educational requirement to become a process server. Like I said, they do a live scan, they do a background check on you, you pay the fees, you fill out the form. And so oftentimes, a lot of process servers struggle at first when they first get registered because they don't know a lot of the rules. There's so many rules. And so they really depend on us. They depend on you. They depend on all of us to provide instructions as to how things should be done. Hopefully, the process servers that you contract with are experts and know what they're doing. We try at CalsPro, our state association, we have a training program that we call CCPS, California Certified Process Server, and they take an exam. They do a similar kind of a class like this for 6 to 8 hours, and they take a test, and if they pass it, they get the designation. So I would ask you to, see if your servers are CCPS designated. Just some type of education and training goes a long way to having your case uh, thrown out the drain. There are actually less process servers now than ever before. The last estimates we did, this was, I think, a year ago, had about 3,500 registered process servers, and that includes corporations. You do have to have a corporate registration. And then the other 200 are photocopiers, I believe, in this number right here. So it's about one per every 10,000 and a half. And they're not evenly distributed. There's deserts of places where it's hard to find a process server. So sometimes service fails because you can't find somebody in a very rural area. And so that is also a challenge oftentimes. Like I said, the industry trends there's actually the number of process servers is gone down about by 40%. About a decade ago, we had about 5,500 registrations at one time in California. We're down to close to, uh, a lot less now, 3,700. And so there's less process servers out there. And there's many reasons. I think e-filing has a lot to do with it. When I got into business, you used to go to the court, right? You do the pickup. Some of you probably remember this. You had your attorney service come pick up the papers, and we'd go file your documents at the court, and then we'd bring them back, and then we serve the papers, file your proofs of services. With e-filing, a lot of companies went out of business. A lot of a small, especially the small mom and pops attorney services left. And so that's been an issue. And me myself growing up, I used to go and research cases and do that sort of thing. So there's an element of expertise and training that you get by doing actually physical filings. With e-filings, it actually changed the whole landscape of how we of the number of available legal support professionals. The economy, the gas prices, again, there's less servers nowadays, and the rise of the gig economy obviously is also another major factor. I see people, it's a lot cheaper to take somebody, take some food to somebody's house on DoorDash than to go and knock on somebody's door 5 or 6 times and get yelled at or get chased at or whatever the case may be. You make a lot more money with some of these gig economy jobs, and it's a lot risky. It's a lot less risky. AB5 restrictions in 2020, you're probably very familiar with AB5. Labor laws also restrict how we contract with process servers as litigation support companies. So that had a big effect also on the process serving industry. Again, I can only say my point is why a service may fail oftentimes has to do with the servers not really knowing the rules, not knowing some of the regulations behind. Like I gave the example of the debtor's exam and so forth. So you want to make sure you do contract with an experienced process serving company that's reliable and gives you lots of communication and is hopefully a one-stop shop. It makes it a lot easier. Examining service of process. I'll go through this really fast, but basically, as lawyers, most of you know why we serve papers. It's to gain jurisdiction. We serve the document so that the court can get jurisdiction over a person, a property, an entity, a business entity, and so forth. And the court cannot issue a default judgment unless the parties are served. A lot of the rules for service of process emanate from the FRC4 rules and CCP Code Chapter 4, which we'll review quickly. So Chapter 4 lays out the different methods of service that are available in California, starting with 415.10. We talk about personal service. Personal service is always the ideal method of service. You actually walk up to the individual or the agent for that company and you hand the documents and they accept service. Service is completed upon delivery, and then we fill out a proof of service, and it's a personal service. I oftentimes get requests to personally serve documents that do not require personal service. And although we always strive to personally serve parties, it's when somebody says, no, I don't want you to subserve it, I need you to personally serve it. Oftentimes when we go to, especially in residences, once we go and we're able to subserve it, but we don't, what happens is when they go back, they don't want to open the door anymore. So I would say, be careful. If the documents don't need to be personally served, don't request that they're personally served unless there's absolute need for personal service. I had an attorney reach out to me a couple of months ago because we had served we had subserved some documents, and they quoted CCP code 41610. That's the corporate code that says, in order to effectuate personal service, you got to serve the CFO, the CEO, the VP, the branch manager. But that's for personal services. We all know corporations can be subserved on the first attempt per 41520 CCP code right here. Section A actually does state that different types of companies, more so, ranging from corporations to partnerships to LLCs to even public entities, can be subserved on the first attempt. There is no diligence requirement when serving companies with summonses and complaints. For individuals, 41520 Section B says that you can subserve it on somebody who's a member of the household or is in charge of the usual place of mailing, upon exhausting diligence. If you've attempted diligence and you're unable to serve it, and diligence is obviously, as you probably all know, defined by local rules. The new bill that just was signed by the governor this year, Assembly Bill 747, we'll talk about Assembly 747 a little bit more, but they're actually defining diligence as 3 attempts on 3 different days at 3 different times. Different counties have different local rules. Some counties like Contra Costa and San Francisco have very specific rules. San Diego requires an attempt before 8 a.m. And those sorts of things are the kind of things that we all need to understand, so that there's no surprise later why your service was quashed. Notice of acknowledgement of receipt, 41530, it works well, I think, in family law when you have amicable parties. Sometimes you may resort to doing that. You just remember you have to get the acknowledgement of receipt signed, and then you attach that to the proof of service, and then you file it with the court. Without the signature, it means nothing. And what often happens is, again, we'll get a law firm reach out to us, say, can you serve it? We sent the acknowledgement of receipt. They never sent it back. And now the party actually has copies of the documents. There are other types of services listed, obviously, in the methods under Chapter 4, Section 415 through 41590. Obviously, postings on like unlawful detainer cases, certified mail sometimes work for out-of-state services, but service by publication is an interesting one. I think when we look at the system in today's modern world, how many of us actually read the paper? It's a bit silly. I get these orders for publication sometimes, and we still do them. A lot of companies still do them. So there was a Senate bill last year that passed. It's SB 85. And SB 85 basically states that you can actually serve now a summons. I'm trying to find it right here. I'm sorry. If no provision is made into this chapter, I'm sorry. The bill authorizes the court to direct a summons to be served in a manner that is reasonably calculated to give actual notice to the party to be served if a plaintiff, exercising reasonable diligence, has been unable to serve the summons using methods prescribed by statute. So they're basically saying if you've exhausted all methods, like service by publication, you can actually, with the court order now, do it electronically, maybe through social media or some other type of form. I've seen it in Illinois and in some other states. It's becoming a little bit more, it's becoming more common, but not, I won't say common. You see it, but it's not uncommon. So all these types of rules, I think, are very important for process servers to know. I think part of the reason why service fails is because there's a lack of knowledge. And it's not just in the process server, but also like using the right forms for judicial counsel, forms for proofs of services, and so forth. I see with federal services, sometimes with district summonses, I may get a request to subserve the documents at the defendant's business. But if you look at the actual AO form, it only gives you the option to leave it with a member of the household or the agent if it's a company. It doesn't say you can actually leave it at the work address. And I get these types of, and when we do that, oftentimes it is challenged. I think there's a lot we can do as legal support professionals, paralegals, attorneys, services, notaries, LDAs, anyone who gets involved in the service of process workflow to help bring the information needed for the process server to actually effectuate service. Oftentimes, services fail because the address is bad. I can't even tell you how, well, it's probably 1 out of 5 sometimes where we don't do the homework. And so try to confirm the target's address when you're submitting an order through. This is a screenshot of the One Legal platform. We have a locator available. Most attorney services have it. We offer a person locator if you haven't done it, but start with confirming the target's location before you send it. It's going to cost you a lot less to have somebody go out there, and sometimes they may not get an answer at the door for 4 or 5 days, and just to find out that the person moved. And so this is one way for sure. One thing you can do is validate the service, validate that it actually exists. Google can tell you, you type in Google any address and it'll show. I've seen Google addresses like where there's in the middle of the strawberry fields in Oxnard. You want to make sure that the address is, it actually is a deliverable address. I typically use the U.S. Postal Office zip code search, and it actually will tell you if the address is actually a deliverable address for mail. So there's a lot of tools available. Use technology to your advantage. You can get professional help through One Legal. Here, we offer multiple types of locating services. List all the parties to serve. Sometimes we'll get, well, I thought you were going to serve the unknown occupants on an unlawful detainer. Be very specific. If you're serving multiple parties, let us know who you're serving. List them. We usually request it's one order per defendant at One Legal, so that way you get one proof of service for defendant. I oftentimes say, oh, just give me one proof, and there's multiple defendants. The court's not going to take that. So you have to submit the right number of jobs in order to get the right number of proofs. In some pre-litigation exceptions, like you're serving a 3-day notice, you could list multiple parties. So that's not really a legal document. But if you're serving in an unlawful detainer case, you're going to need a proof of service for every party. And don't just assume that the unknown occupants is going to be served. We have a pretty cool new feature at One Legal where you can just press the button and say, I want all unknown occupants to be served. And you'll also be able to, from our library, upload the prejudgment claim of right to possession. So some really cool stuff out there, but just make sure that you identify the right targets. Oftentimes, a description goes a long way. I've personally served papers when I was going to college for many, many years and afterwards. And you knock on the door and somebody answers the door and they say, they're not here, and they slam the door. What do? Is it them? I don't know. But if I had a description that told me they were a certain height or they had a certain look or they have a tattoo, anything that would kind of lead me to believe it's them, it would probably increase my service success rates substantially. Process servers try to, verify the address oftentimes by checking with the neighbors, but that sometimes alerts the defendant that they're trying to be served. So it's a fine balance. But I would say a picture is worth 1,000 words. If you have a picture, obviously in family law, there's pictures and personal injury cases. There's usually a driver's license. There's certain things you can and cannot share, so be careful what you share. We don't need any social security numbers, but you can give us a picture of somebody. If you can give the picture, that helps a lot with evasive targets. If we know what they look like, it helps a lot. And I've had this one case where they wanted us to serve an individual at a funeral, and they didn't have a description for him. So it's impossible. You're going to go to a funeral, which is already kind of ethically questionable, and then start asking for this person and try to find them and serve them. So again, a photo perhaps would have gone a long way there. But again, it's up to the process server if they want to accept that job or they don't. Instructions. Instructions are always key. Provide instructions. If you want something in particular done, obviously ask for it. We have a special instructions box here that you can put in there. Please attempt on Tuesday between 7 p.m. and 9 p.m. That's when they're home. Well, that's going to help. If you don't put that, the server's going to go, X amount of times on different days of the week and not know that. Any details as to like their movements or their behavior, their come and goes, movements help a lot, obviously, in trying to avoid a non-service return. Obviously, clearly communicate deadlines. If your papers have to be served by a certain time, like a debtor's exam 30 days before the hearing, make sure you put it in the special instructions. If you're serving small claims, small claims has different rules, 15 days before the hearing. If it's out of county, it's 25 days before the hearing, and so forth. So make sure you specify your absolute deadlines. And oftentimes I'll get also from paralegals and law firms incomplete packets. You forgot to send me you wanted to add an additional document that you just got back from the court, mediation documents or case management statement or whatever the case may be, and we've already gone there and they've already attempted service, or they've already served the papers. And so double check your work. I think that if we take the time to go through the documents, provide all the information that you have, do a little bit of research prior to sending the work or the job, I think it'll help the chances of personal service or effectuating service more than you possibly think. This is a good one. Avoid asking servers to do illegal things. Servers can't break into properties. There are exemption rules. Process servers have some of the same type of exemptions as police officers and firefighters when it comes to assault penal codes and trespassing penal codes. Penal code 602N actually allows servers to enter a do not trespass property sign by car. And 602N basically gives us servers a right to be on your property in the course of due process. What we teach most of the process servers in our CALS Pro classes is the moment somebody tells you to get off their property, you need to get out. You need to move out. So it's not worth $100 to get shot or to risk an injury or an altercation of some sort. We don't dress up. It's not Hollywood. We usually, if you use ruses, you piss people off. I've done it and I've regretted it. You don't ever want to impersonate a police officer or a firefighter. I've seen people impersonating FedEx and Amazon delivery personnel. Servers are professional, despite what Hollywood sometimes shows us in some of the movies. There's a lot of professional legal support professionals out there that, like I said earlier, that are investigators and process servers and notaries and even paralegals and have JDs that do this as sometimes part-time or full-time. And so they're professionals and they're not going to try and break the law just to get your paper served. I created a quick little checklist of things for the law firms to look at and make sure that they, try to complete them before sending work out to whoever your service provider is. I think people would appreciate that. But again, just verifying the address, descriptions, specifying deadlines, communicating requests, that sort of stuff is pretty all commonsensical. Use your available technology. Um, One Legal, we offer a bundling package, or if you just want to, in a case initiation, you want us to file, serve, and then file the proof of service, you can submit it at one shot. Really cool. A lot of companies out there offer different enhancements and benefits. Our company is owned by a legal software company, and we do integrations with practice management programs as well. So see what's out there and take full advantage of the enhancements that are out there. Legal tech is a very fast growing industry. Again, confirming an agent. Oftentimes I'll get a service on a business form, a business entity form unknown, or business organization form unknown. We call those BOFUs. And the attorney, nobody knows what type of entity they are. They list that on the complaint as business organization form unknown. But we need to have the name of the agent or the name of the owner for serving a BOFU. Here, obviously, for the Secretary of State, we're talking about corporations and partnerships and LLCs and that sort of thing. But for non-corporations, it's very useful to have the name of the actual person that we're trying to serve, not just some construction company doing business as something, because it creates problems on the proof of service as well. So it's good to know who the actual authorized person is when you're serving a business entity and verify it. It's pretty simple to verify these types of things nowadays with social media and technology. There's a lot of tools out there. Our software program allows communications through messaging. The One Legal platform has this really cool feature. We released this about 2 years ago, I believe, where we can send messages back and forth, and we have a team that actually, if you send a message, actually is in charge all day to go through these messages and alert the process server. So one, for example, I'll say is like you forgot to give us the apartment number for a service, or you got additional documents that need to be added to the service packet. This is a way to actually communicate with us without having to call the 1-800 number. God bless the people that do the customer support. They're pretty fast. They answer the phones, I think, very, very fast now. I think it's under 2 minutes, but it's a lot easier and you have a lot more accountability sending stuff through the actual software, because obviously there's a track there. You can upload documents, you can put special requests. And at the same time, we are also able to let you know, like we went there and they say they don't live there, they left, and then you can go back and say, no, that's the mom. They actually receive mail there. It's okay to subserve the documents when you obtain diligence. Those sorts of things obviously help go a long way in getting your documents served timely. With that being said, so there's people, there's processes, there's communications, but there's also a lot of things that we can't control. And so trying to look at this phenomenon holistically. I wanted to incorporate this also for you to take into consideration. In 2025, obviously, the American political climate is a lot different than it was 10 years ago. The ICE raids, for example, in California, people don't want to answer the door. Asians, Hispanics, you name them, any type of immigrants are typically pretty reluctant to open the door if they don't know who you are. The housing crisis, we have over a fourth of all homelessness in the United States, 200,000, I think, in California alone, out of 800,000. So there's a lot of people that have been displaced. There's people that don't have a house, or that move around, or maybe they're sometimes they're in multiple houses. You have multiple families living in one place. And so it's hard to verify addresses nowadays. Does somebody actually live there? Because they don't have a electricity bill tied to their name or so forth. For process servers, it's definitely, I've written a couple of in the past articles about self-defense, and we don't want process servers to get hurt. We're very concerned about safety, but people are a lot more militant than they used to be. And so we have to be careful. We teach our process servers to always practice safety first. And so sometimes a document, it may not get served because there's a menace. There's a danger involved. And we oftentimes will report those. There are resources out there that track violent individuals, violent areas. And so we will typically refer that to the sheriffs if the process server doesn't feel comfortable trying to effectuate the service any longer. I definitely have seen, well, I think it was just last year, a process server was shot in Missouri, and the sheriff also was shot. We had 2 deaths over a notice to pay rent or quit on a property. So sad. But it is more violent out there. More people have guns. And so we care about that, and that sometimes has an impact on our ability. Inclement weather, you think, oh, I know in the past we've had servers out in like Alpine or Glenn County and during winter, and the server can't get out there because it's full of snow, and that sometimes may happen. Sometimes that causes delays. But you'd be surprised now also with all the fires in California the last couple of years. I've actually gone. When I was in Santa Barbara, I tried serving a paper up in Montecito, and this property was completely gone. And the attorney wanted to serve somebody, the construction worker, anybody. And we went multiple times. There was nobody ever there. There was a phone number there that we ended up getting. But again, sometimes these types of disasters make it very impractical to actually serve somebody. There's a lot of family displacements, especially in Altadena, Pacific Palisades area, Palos Verdes, Ventura County as well. So be mindful of that. This is a more prevalent issue, I think, and it's COVID, the post-pandemic world. I'm sitting here talking to you through remotely through Zoom. Many of you are doing the same. Remote work changed the way we work. As you know, there's remote depositions now in courts. There's a lot more e-filing. Everything's becoming more digital. And so with remote work, what we have found is that there's more people working from home. Before, if somebody was being evasive, I remember the paralegal would say, well, they leave to work every day at 7 and they usually get back around 6, or they have a job and, they have to go. They have to go to work. And so nowadays with remote work, that's not always the case. There's less accessibility. People are more suspect. I asked some of my managers yesterday, I told them about this event I was going to talk about. And I said, why do you think it's the most important reason why services fail? Several of them said, oh, evasive defendants. Okay, what else? And one said, yeah, maybe not enough information coming across from the paralegals, if we would have had a picture, maybe. But somebody also said this culture of fear. People are a lot more timid. People are a lot less social nowadays. And I think that may be an effect of COVID and the pandemic we went through in 2020. People are less prone to open the door. I know I'm a big chicken. I don't open the door to anybody. If I don't know you, I'm not going to open the door. So that's an issue. More businesses are being run from homes, and that causes issues sometimes because there's no physical address. And I've had servers say, "Well, I served the wife." But they were trying to serve the agent for a company. You can't serve the wife. It's not a legal service if you serve the spouse of the agent at their house. Now, there is exceptions to the rule. You could argue if the Secretary of State has the home address as the business address. If the wife or the spouse said, I work for the company, I'm the VP of the company, I'm the general manager of the company, you could get away with that. But again, there are limits to what you can get away with. CMRAs, a lot of people have these commercial mail receiving agencies, and we can serve summonses there all day long, but you can't serve a subpoena. You can't serve a debtor's exam. There are certain documents that require personal service, a TRO. You can't serve it a CMRA. And if the only address you have, if that's the only address you have, you're obviously not going to be successful. Technology, along with the pandemic, there was a lot of push for technology nowadays. Ring cameras are a huge thing. Ring cameras can work for and against process servers. You can see somebody knocking on your door with documents in hand or holding a briefcase, or a stranger. You're going to tell them to leave, to get off the property. You used to be able to walk onto somebody's property, and maybe somebody that was reluctant to open the door may just open the curtain and look. And if we had a description of what they look like and said, that's them, and yell across the window, you're served. I'm putting these legal documents here. It's a summons and complaint, leaving them here on your doorstep. Have a nice day. It was done. But now with Ring cameras, you can't see them. You don't know where they're at. The essentials of process serving require close proximity to the person being served. And so it makes it almost essentially impossible sometimes. I've had servers say, yeah, the guy on the Ring camera said to leave the documents. And then a month later, the guy said, well, I was on vacation, Your Honor. That's an invalid service. And we have to start all over again. So Ring cameras are a challenge. I'll tell a story. There was a service that was challenged a couple of weeks ago or a couple of months ago, where the defendant claimed that the process server walked up to the door and just left the documents there. And they had a video of it. And so when we talked to the server, we did a risk assessment and talked to the server, and he had pictures and he told the whole story. And what had happened was he actually pulled up at the house. He had been there numerous times. He had already verified the address, and there was a lady that they were trying to serve, and she was in the driveway, I think, in her garden. And as he approached her, he said, I got some legal documents for you. She ran in the house and shut the door and told him to leave. So he declared service and left the documents on the doorstep and walked away. And so we let the attorneys know, and they requested that they show the first 5 minutes of the Ring camera footage to the judge, and the service was upheld. So Ring cameras can work for and against process servers. And so again, I say take advantage of technology. There's actually a buddy of mine sent me this Wikipedia, how to avoid being served. A lot of social media can help us find and get pictures of people, kind of know where they're at. But there's a lot of people out there that evade service. And this one, I put a link there to it. It's pretty funny. There's a whole document on what to say if someone's trying to serve you, what to tell your coworkers at work. Don't tell them your schedule, that sort of thing. So it's today's world. With that being said, I touched a little bit on Assembly Bill 747. The SPARE Act is the Service of Process Accountability Reform and Equity Act. It was introduced this past year by Assemblyman Calra out of San Jose, I believe it is. And they were pushing for a lot of restrictions and on process serving, a lot of more transparency. They wanted process serving badges on every proof of service, that sort of thing. But the big part of it was that they wanted photographic evidence and GPS data on proofs of services. And so some of the things that are going to go into effect starting January 1 of 2027 will be some of those requirements. CalSPRO went back and forth for several months. It was a busy legislative year for our association. And there's some good things, and there's some things that are still up, that are questionable. They're going to be able to challenge more of the default judgments based on several factors. There is going to be a public process server registry that they want on every county website. Reasonable diligence will be codified. But the big one was the photos and the GPS data. And they wanted pictures of the actual papers on the door, if you were posting papers on the door. And we try to give some real de facto, real world examples of how that's not always possible. We take pictures. Usually, one legal, we're already in compliance with a lot of what they're asking for. We provide GPS data, accountability reports, photos of every attempt, so that we have verification and transparency already. but people don't want to be taken. You don't want to take a picture of a person because it really incites them to get violent. The argument was made, well, if you can take a picture of an Amazon package, why can't you do it of the papers? And so we are now this year we're going to look at the bill, and I know the plaintiffs bar and the sheriff's association and the private investigators, they all are now beginning to chime in on exemptions or and so forth. I would like to return maybe next year if you would have me and maybe talk about the changes in the law pertaining to service of process starting January 1, 2027 as per the SPARE Act AB 747. But definitely the biggest change in process serving I have seen in decades, and it's going into effect a year in about 14 months. With that being said, it's been a pleasure being here with you all. I hope I was able to cover as much as I can in 54 minutes. We can leave it. We can open it up for questions if anybody has any questions on any of the material that I covered.
I think you might have answered it already. There's two things in the chat box about workarounds when you know the person you're trying to serve is in the house, but they refuse to get the door. And
Yeah.
How do you get around that?
That's a good one. That's a good one. I would say this. If one thing that I didn't mention is sometimes people are embarrassed to get served at their job. So I tell customers, sometimes some of our government agencies, if you have both a resident address and a business address where they work, if we're able to tell them, through the door, I hate to say it, but if we say, hey, if you don't open the door, we're going to come to your work and we're going to serve you at work, I can't tell you how many times that works. People will open the door and just put out their hand. You can't trespass, but you can do certain things. You can catch them off guard. If they're refusing to open the door, sometimes returning the next day or early morning and just honking the horn just to get somebody to come out. That's the number one thing when you're serving people at their residences is getting the door open. That's the number one thing. If you can get somebody to open the door, you're gone 50% of the way.
Okay. And another person put in, when serving the registered agent, do you have to personally serve the registered agent, him or herself?
It depends where you're serving them. So if the Secretary of State has an agent for service of process at a location, and you go there, it's a business location. Sometimes there are attorneys or CT Corporation, CSC, those types of agent companies accept service. You can go there and you can leave it with the person in charge per 41520 CCP code section A. But if you're serving the agent at their house, and sometimes this is what happens with default corporations, forfeited corporations, you only have the house address, and maybe it's not just the agent, but maybe it's the CEO or the president. You can't leave it with the gardener. You can't leave it with the wife because they have nothing to do with the company. And so it depends on where you're doing it.
And another question I have is, what's the typical number of attempts when serving someone? Is there a ballpark figure as to how many times it might take and what one should expect?
Yeah, it's a great question. That's something we've been fighting about for years. There is no, diligence is defined by judges typically. At One Legal, we offer 4 attempts per service. We try to make them at different days, different times, depending on the local rules also. Like I mentioned, I think in Contra Costa, you need a Saturday attempt. So we will make a Saturday attempt as well. But for like getting an order for publication, you need 6 attempts. For unlawful detainer cases, usually depending on the county, 3 attempts will suffice to get an order to serve summons by posting and certified mail. So it varies per county and it varies per document type.
Great. I think with that wonderful, wonderful information, I'm going to turn it over to Mirage and we'll finish out the session. Thank you so much. Great information.
I just have one question.